A moot is a bit like a legal debate. There's two teams, each side has two people. We would prepare a problem beforehand. On the day we'd present either for the appellant or the respondent. There would be about 10 minutes of argument per person, and during our argument the judge would be able to interject to ask questions if things aren't clear, or to put to us that perhaps things we're saying aren't correct. And then at the end the judge will come to a determination of who's won the moot.
How well the moot goes depends a lot on the judge you have and the kind of questions they ask you, because they can make you undermine yourself quite easily in your responses to their questions. But then at the end of the day, they're judging you, so it doesn't mean if they don't ask you hard questions that they're agreeing with you.
Mooting is, I think, like debating but in a legal context, and I probably think of it that way because I did a lot of debating at high school and then moved on to mooting when I was in law school. I thought this was a lot of fun, actually. It was a really interesting question, and it wasn't really an area of law that I've looked at for some time, so it was a bit of a challenge. But I think partly because I'm not studying this kind of law at the moment, it was really good to just really stick my teeth into something quite sort of different.
I enjoy mooting. It's quite an academic activity. It's similar to an essay insofar as it's got similar academic resonance, but you get the fun of standing up on your feet and arguing points and public speaking. And in the end, it turns out to be quite a sociable activity. This is the first time I've done a moot in Oxford, and it's slightly different to ones I've done previously at other universities, insofar as it requires me to moot both sides of the problem.
Suggested by my learned friend to found the cause of action for promissory estoppel have been inappropriate and unfortunate extension of estoppel jurisprudence.
Just to clarify, he said at one point that my submission suggested that the doctrine of consideration should be tightened up so as to overrule cases such as Williams and Roffey. If I could just clarify that the very point I was making is that it should in fact be loosened so as to allow.
I didn't think we were going to win the semi-final, and I definitely didn't think we were going to win the final, so I was very surprised. But in both cases the judge said it was extremely close. The final was different because the judge was he interrupted a lot more, and he was much more concerned about the practical outcome of the case, whereas before it had all been about the strict grounds of appeal we were bringing the case on.
We won £500, which is wonderful, and also the opportunity to do a 2-week vacation placement at Shearman and Stirling, which is really exciting, and we're both hoping that we'll be able to take them up on that offer. We both actually came back from Paris today, where we're studying abroad, so the prize money will hopefully at least cover our expenses for getting the train back here.